Hello, good evening. Welcome everyone to tonight's program. My name is Joe Eggers. I'm the interim director of the Center for Holocaust and Genocide Studies here at the University of Minnesota. As we're all aware, on Friday, the International Court of Justice decided that Israel has created plausible conditions for genocide. But what does that actually mean? To help us understand the ICJ's decision, I'm joined tonight by Dr. Melanie O'Brien, visiting professor at the center. Dr. O'Brien is also the current president of the International Association of Genocide Scholars, serving in her second term. She's also an associate professor of international law at the University of Western Australia. Dr. O'Brien has been involved in work related to several genocides and acts of mass violence around the world, including the ongoing ethnic cleansing in Nagorno-Karabakh, the genocide of the Rohingya in Myanmar, and many others. Dr. O'Brien has provided testimony at several government and intergovernmental agencies, most notably at the United Nations in this last November. And before we begin tonight, I want to establish a couple of ground rules. First, I understand that emotions are running high on both sides of this conflict, and I ask that we treat each other with the dignity and respect we all deserve. And second, Melanie will be speaking from her position as a legal scholar, and thus won't be speculating about potential events. After our Q&A with Melanie, we'll open it up to your questions, and you can post those in the chat. My colleague Nika Srimak will be there to kind of coalesce questions, because I'm sure there will be plenty of overlap. And then finally, we're going to be recording today's discussion and archive it on the center's YouTube channel. So with all that in mind, Melanie, I guess I'll give you a softball question. Can you start by just giving us a brief overview of the International Court of Justice?
This is a really good place to start, because I know there's a lot of confusion amongst people who aren't like me, who aren't working in international law every day, about what are these different international courts. So the International Court of Justice is also known as the World Court, and it is a court that adjudicates disputes between states. Now, when I use the term states, this is our international law lingo for countries. So basically, when one country alleges that another country has violated international law, and they try to resolve this diplomatically and through diplomatic channels, and eventually they find that they can't resolve that, then one country will take another country to the International Court of Justice, alleging violations of international law, such as a treaty, for example.
Great. And so then how would the ICJ be different from the International Criminal Court?
So the ICJ is focused on states and what we call state responsibility. So the responsibility of a country for violating international law. The International Criminal Court is about individual criminal responsibility. So in a way, it's similar to a domestic criminal court, where someone is charged with a crime and put on trial and then either acquitted or convicted. The International Criminal Court also does that, but with regards to international crimes, namely war crimes, genocide, crimes against humanity, and the crime of aggression.
So this would be, the ICC would be then we're more familiar with something like the case against Omar al-Bashir in Sudan, right?
Yeah, so that's actually the Omar al-Bashir case, the former president of Sudan. There are genocide charges laid against him by the International Criminal Court. He has not yet faced trial, and it remains to be seen whether he will be surrendered to the court. But in that case, this is not about Sudan as a country being responsible for genocide in Darfur, but it is about the role of al-Bashir as president in his individual capacity, being responsible for individual crimes, including genocide. In the International Court of Justice, it's about the country as a whole. So they're not necessarily looking at one individual's responsibility, but more, what does the country do? What does the government do? What are the government's actions? What are their policies? What laws have they enacted? And how do they implement them to ascertain the type of behavior of states? And they look at people who represent the state as being part of the state. So the government, the military, public servants, diplomats, those type of people, to see, what was the state actually doing in this case.
So obviously the ICJ has been in the news because of the South African versus Israel case. But is the ICC investigating any potential crimes in Palestine?
The ICC is investigating, and it has been doing so actually for some years. So that was already an existing investigation that was started at the request of Palestine, and the International Criminal Court decided that it did have jurisdiction. So what this means, just to be clear, that Israel is not a state party to the Rome Statute of the International Criminal Court, which is the ICC's founding document, but Palestine is. The ICC has allowed Palestine to become a party and has opened an investigation. So that means that the ICC would have jurisdiction over any crimes within its jurisdiction. So those four I mentioned: war crimes, genocide, crimes against humanity, and aggression, within the territory of Palestine or committed by Palestinians anywhere, so outside of the territory of Palestine. So the ICC is already undertaking an investigation, and the prosecutor has been on the ground since the 7th of October, engaging with what is going on, and they are investigating. And what I can say is that we would expect at some point to see charges to be brought against alleged perpetrators of any crimes that have been committed on or since the 7th of October, either within Palestine or by Palestinians outside of Palestine. Those charges may be a long time coming because these crimes are really, really difficult to prove. So there is a sense of discussion about why haven't charges been laid yet? Well, we're not talking about a single crime. We're talking about mass atrocities, and they are really difficult to prove, and they require a significant amount of evidence to be gathered, physical evidence, documentary evidence, testimonies. And so the Office of the Prosecutor, their investigators will be looking at gathering that evidence and making sure that they have, the start of a substantial case before they can bring it to the court to issue an arrest warrant. So I'm sure there will be charges brought in the future, but it's just a matter of them being able to put together the evidence in the first place to be able to bring those charges.
So if we bring it back to the ICJ, can you provide some background, some context for the case? How did this case come from South Africa to the ICJ?
So South Africa brought this case before the ICJ in December, alleging that Israel is in violation of its obligations under the Genocide Convention, obligations including the prevention and punishment of genocide and incitement to genocide. Now, people may be wondering why South Africa, it's not South Africans that are being subject to genocide, so why is it South Africa? So South Africa has said that, firstly, its interest in the case is its history of apartheid, and so its sense of connection with the people of Palestine and support for the people of Palestine. But secondly, and really very importantly, is the fact that as the International Court of Justice has said several times, and including in the ruling that came down on Friday, is that any state that is a party to the Genocide Convention can bring a dispute against any other state that is a party to the convention. And that is because of the special nature of what the Genocide Convention does. It prohibits genocide, which is a horrific crime that is seen as an international crime because it shocks the conscience of humanity and it impacts peace and security on a global scale. So this obligation on states to prevent and punish genocide is so significant that the court has interpreted this convention to be one where any state party can bring a dispute against any other state party. Now, in legal terminology, we call it obligations erga omnes partes, and this means an obligation owed to everyone. So this means that any country that is a state party to the Genocide Convention owes the obligation to everyone to prevent and punish genocide. And this is the legal basis for South Africa bringing this case. And in fact, thinking about that, essentially, well, any other state that's a party to the convention could have brought this case. And it's not the first time we've seen this. Recently, in one of the currently ongoing cases under the Genocide Convention before the court, the Gambia brought a case against Myanmar alleging commission of genocide against the Rohingya people. And this was under the same principle. So this is not unheard of, and it has been constantly repeated by the court that this is the special nature of the Genocide Convention. So that's how South Africa was able to bring this case.
So then that explains why South Africa has that burden to prove at the preliminary measures of the case.
Yes, so the stage that we're at now in the case is called provisional measures. Now, this is the International Court of Justice term for something that perhaps might be called interim orders or interim measures in other courts. The merits phase of this case, which would be where the court would adjudicate whether or not Israel has breached the Genocide Convention, is actually many years away if it gets to that stage. So the provisional measures is where South Africa has requested that because of the urgency of the situation and the serious risk of the violation of rights under the convention, they requested that the court issue provisional measures against Israel. So provisional measures are about urgency of a situation, a risk of a violation of rights that fall under whatever the convention is that's at question, and the need for the court to essentially try to either maintain a status quo or to prevent further violations of the convention in question before they actually get the chance to adjudicate on the merit stage.
So can you maybe talk a little bit about some of the preliminary measures both South Africa and Israel argued in the hearing earlier this month?
Yes, so it started with some written arguments from South Africa, but then the court held 2 days of oral hearings. South Africa's main arguments were that, first of all, what we're looking at is the context of decades of discrimination and apartheid and regular attacks on Palestinians. They also looked at the context of mass bombing and displacement and killing of civilians and destruction of civilian infrastructure since the 7th of October. So those are the two contexts in which they were arguing that genocide is taking place. They also went into detail about statements from Israeli leadership, military and civilian leadership, the media, and other people indicating genocidal intent. So these types of statements were statements of destruction, statements of elimination, and statements of dehumanization, referring to destroying Gaza, the evil of Palestinians, and how there are no innocents in Gaza. South Africa argued that these provisional measures were urgently needed because of the significant humanitarian crisis in Gaza, the huge number of deaths that have been taking place, and the extensive destruction that has occurred. Israel, in response, argued that they comply with international law and that they provide aid to Palestinians, so therefore there is no genocide. They also argued that the statements that South Africa was using to show genocidal intent are random and not relevant. They argued that only statements in which Israeli leadership has said that Israel complies with international law are relevant. They also argued that actions and statements of soldiers are not reflective of Israeli state policy. They argued that Israel is acting lawfully in self-defense in response to a terrorist attack from a non-state armed group, namely Hamas. They also argued that any collateral damage to civilians and civilian infrastructure was lawful and was permitted under the laws of war. and that essentially this was Hamas's doing because Hamas has embedded itself within the civilian infrastructure and population. They said that there was no need for the court to issue provisional measures because Israel is already complying with international law and is already providing aid. They also argued that the court shouldn't issue an order to suspend military operations because of the fact that there is an ongoing armed conflict and that would jeopardize Israel's capacity to defend itself. So quite lengthy, but also a bit of a nutshell to cover the arguments from the two sides in court.
So let's talk a little bit about the decision on Friday. I know it came out really early at 6 o'clock in the morning, and you were up and following it then. Could you maybe summarize a little bit about what the court actually ordered on Friday?
Yes, the time difference means, as an international lawyer working early in the morning or late at night. So essentially what the court found was that there is a plausible risk of genocide in Gaza. It found that because of the catastrophic humanitarian conditions and the high numbers of deaths and the extensive displacement, the extensive destruction of civilian infrastructure, that it is plausible that there are violations of the Genocide Convention happening, and that it is plausible that there is a serious risk of genocide in Gaza of Palestinians. It, as a consequence, it did issue provisional measures. So first of all, it ordered that Israel must take all measures within its power to prevent the commission of acts of genocide that are listed under the convention. It ordered Israel to ensure that its military does not commit acts of genocide. It ordered Israel to take all measures within its power to prevent and punish the incitement of genocide. So that's connected to the statements that I referred to that South Africa used. It ordered Israel essentially to provide humanitarian aid to Gaza. It also ordered Israel to take effective measures to preserve and prevent the destruction of any evidence relating to allegations of crimes of genocide. And the last thing that it ordered was for Israel to report to the International Court of Justice within 1 month of the order about its compliance with the provisional measures order. So that's the nutshell. One of the things that it did not order that South Africa had requested was a ceasefire. That was a difficult thing for the court to be able to do because that doesn't really fit within the law that it was restricted by, namely the text of the Genocide Convention. Yeah, however, essentially thinking about what it did order, Israel is going, if it is to comply with the order, Israel is going to have to reevaluate its actions that it is undertaking in the armed conflict. And it is also going to have to permit humanitarian access. And one of the things that humanitarian aid providers have been stating for weeks, and particularly this has worsened in January, is that they cannot actually provide humanitarian aid without a ceasefire because the conditions of the armed conflict are prohibitive to the logistics, the actual physical distribution of aid to the Palestinians in Gaza. So even though a ceasefire wasn't ordered, there are provisions within that order from the court that are connected to the idea of changing how the war is being fought and possibly the consideration of a ceasefire.
So the decision wasn't a unanimous decision by the judges. I'm wondering if you can maybe summarize or highlight some of the dissenting opinions of the court.
Yeah, so what's interesting is that it was almost unanimous. So it was a judges bench of 17 judges, 15 regular judges from the court, and 2 what we call ad hoc judges. So 1 ad hoc judge appointed by South Africa and 1 ad hoc judge appointed by Israel. Now, most of the provisional measures they were almost unanimous. They were either a vote of 16-1 or 15-2. There was 1 judge who dissented on all of them and issued a dissenting opinion, and that was the Ugandan judge, Judge Sebutinde. And her opinion was that the Israel-Palestine situation is a political dispute, not a legal one. She also argued that South Africa had not demonstrated genocidal intent, and so therefore, there wasn't even a risk of the commission of genocide under that. So as a consequence, she argued that provisional measures were not warranted. Her argument about it being a political dispute is well recognized among scholars as being essentially quite absurd, because there are so many legal issues around the Israel-Palestine situation, many legal issues. It's not just political. There are legal issues about the statehood status of Palestine, for example, the status of occupation of Gaza, for example, the application of the laws of war during the conflicts as another example. So there is no way that you can argue that this is merely a political situation and not a legal one, because there are many legal questions that are raised with this. The other judge that issued that did not vote for all of them, that only voted for 2 of the measures, was the ad hoc judge appointed by Israel, Judge Barak, and he voted for 2 of the measures, one of which was calling on Israel to prevent the incitement of genocide. And he voted for that to discourage damaging rhetoric and to decrease tensions. He also voted for the measure ordering Israel to provide humanitarian aid and humanitarian access. But all of the other ones he voted against because he found his determination was that it's an armed conflict and the appropriate legal framework to apply would be the laws of war. He determined that South Africa had not presented proof of genocidal intent. So those are the 2 interesting, dissenting opinions that came about with this. But I think ultimately it's really striking that it was almost unanimous. A whole bench of judges from different legal backgrounds really came together on this in agreeing that these provisional measures should be ordered. So that does tell you the seriousness with which the court sees this situation.
So I know we prefaced tonight's conversation by saying that you wouldn't speculate on anything, but I wanted to take it back to maybe some of the provisional measures and the order. What's the status of those? And I know speculate, but will Israel comply with the order? And what's the enforcement mechanism with something like that?
Provisional measures, like all judgments of the ICJ, are binding. They are binding only on the 2 states that are a party to the case. So in this case, South Africa and Israel. And those states are bound to comply with it. And a lot of people talk about this and say, oh, well, it can't be enforced. But actually, there's a greater than 50% rate of compliance with these types of measures. It's just that when states do comply, it tends not to make the news as much. So people don't hear about that. And part of this is because states agree to this system of international law. They agree to the jurisdiction of the International Criminal Court. And so they take this system seriously, and they do volunteer to respect it and be part of that. They also generally weigh up the costs and benefits of complying with these orders. And when I talk about costs and benefits, I'm not necessarily just talking about economic or financial costs, although that may certainly be part of it. But I'm talking about as well the political ramifications, the international relations ramifications. How will this impact their relations with other countries if they don't comply with the order? So Israel is consistently saying that it has an unwavering commitment to international law and that it complies with international law. And with this order, if it does not comply with the order, then blatantly it is not complying with international law. So that will go contrary to the way that Israel presents itself. The evidence so far is that Israel does not intend to comply with the order, or at least all of the order. They had already stated before the order was made that they were just going to continue to fight this war until the end, regardless of what The Hague said. And their response has been similar since the order has been made. They have been quite dismissive of the order, to the point, for example, where they've been putting statements on social media. The National Security Minister, Itamar Ben-Gvir, just posted on X, formerly Twitter, just simply 2 words that said, Hague Schmague. So essentially, we can probably say that Israel will comply with the obligation to submit a report at the end of the month, but what I would predict is that they will say that they were already complying with those orders, similar to what they argued in the actual provisional measures hearing, that they are already complying with international law, they weren't committing genocide, and so therefore they didn't have to change what they were doing.
So what comes next? What's the next steps in this case?
So first of all, the next step will be Israel submitting its report a month after the hearing. There may be further steps in provisional measures because this has been happening in some other cases. For example, there's a case before the ICJ under the Convention on the Elimination of Racial Discrimination between Armenia and Azerbaijan, and Armenia has actually made additional provisional measures requests. So that may be something that continues to take place over time. Other than that, the next steps in an ICJ case are what we call preliminary objections. And that is where I would likely predict that Israel will make arguments that the ICJ doesn't have jurisdiction to hear this case. That's probably the biggest argument that we'll see at that stage, but that may be maybe even a year away. So these cases take quite a long time to process. So if that hurdle is passed, if the ICJ finds that it does have jurisdiction in this case, after that, it will eventually progress to the merit stage, but that could be years away. Sometimes these cases can take even a decade to progress through once they get to that stage. And it's the merit stage where the court would then make a decision about whether or not Israel has violated its obligations under the Genocide Convention to prevent and punish genocide.
So you mentioned a little bit earlier about a case between Gambia and Myanmar. Can we get a blueprint from that? How far has that gone?
Yeah, so that's a little bit further, but not much. It has had the preliminary objections phase where Myanmar predictably argued that the court did not have jurisdiction, but the court has found that it has jurisdiction. So that case will progress at some point in the future to the merit stage. And that was also a case where the court issued provisional measures against Myanmar and they were quite similar actually to these ones, in the sense that they ordered Myanmar to comply with the Genocide Convention to prevent the commission of acts of genocide.
So maybe can you talk a little bit more about the merit stage a little bit? I know you said it's going to be potentially years down the road, but what is it exactly, and any idea when it might happen?
I don't have any idea. It's up to the court. So the court sets a time frame for every step of the way. And even those timeframes can be changed as well. So, for example, if the court sets a time frame for the submission of, for the deadline of written submissions in a particular part of the process, they could be changed if one of the states asks for an extension. So it's really difficult to say what kind of time frame we're looking at. I can definitely say it will be years before the merit stage is reached. And what happens in the merit stage is that is where both sides will submit, like they will make very significant written and oral submissions to the court, very lengthy, and in this case, I would imagine very thick documentation supported by a lot of evidence on each of their sides to make their arguments. So South Africa's submission, if I recall, and don't hold me to this because I'm not looking at it, but I think was 84 pages to initiate this case. So that seems like it's quite long, but I would anticipate that the submissions that both sides would make in a merit stage would be significantly longer than that. So it will be a huge, huge case for the judges on the bench to have to adjudicate, because they will have to look through masses of evidence. And the other thing that is different about this case, so the court has previously adjudicated disputes under the Genocide Convention between Bosnia and Serbia and Bosnia and Croatia. And one of the things that made those cases essentially easier for the ICJ was that the International Criminal Tribunal for the former Yugoslavia had already had international criminal cases about the crimes that took place in the former Yugoslavia. And so the court could rely on the findings and the evidence from that tribunal. None of that exists here, at least not yet. As I've said, the International Criminal Court is investigating, so perhaps there may be some cases, but again, they also take a long time. But at the moment, we can say that the difference is that the ICJ doesn't have evidence before it that was brought before criminal tribunals, where this was explored in great detail in trials that last for even months of time with just huge amounts of evidence. So the ICJ will essentially be the first court to be looking at this as far as we know. And so they will have to go through a huge amount of evidence. And that's part of why it will take so long.
So you think you've kind of mentioned, you've obviously mentioned Gambia and Myanmar. Are there other cases before the ICJ involving genocide?
Yes, so there's been a bit of an uptick lately in states actually implementing the Genocide Convention, which is great because that's what it's there for. And the use of the law can be preventative. So bringing these cases against states for alleged violations of the Genocide Convention is a way to help prevent future genocides. So we have the Gambia v. Myanmar case, which is ongoing, as I mentioned. And the other case is a case that Ukraine brought against Russia in 2022, not long after Russia invaded Ukraine. It's quite an interesting case. It's very different to any of the others. So in the Bosnia-Serbia, Bosnia-Croatia, Gambia, Myanmar, South Africa, Israel, there are allegations that the court is, allegations that a country is committing genocide. The Ukraine-Russia case is very different. So Russia used a justification that genocide was taking place in Ukraine as their justification for the invasion. So this is a false claim. There was no genocide taking place in Ukraine. And so Ukraine has said that this is a violation of the Genocide Convention in the sense that Russia is not applying the convention in good faith as it should be doing. It's making up a false genocide as justification to come in and, allegedly protect the people of Ukraine. So this is a completely different situation before the court, and it'll be really interesting to see where that goes.
So maybe do you have a sense of how some of these other cases, either Ukraine or Gambia, or maybe some of the cases in the former Yugoslavia and the Balkans, maybe have influenced the ICJ in the South Africa versus Israel case?
Yeah, absolutely. The court has been following its own jurisprudence. And I think one of the most important ways that it has done that is that it continues to state about this special status of the Genocide Convention and that any state can bring a case under the Genocide Convention. And that reinforces this commitment of states to everyone to prevent and punish genocide. So I think that's really important. The other thing is that it has followed suit in terms of thinking about the provisional measures and the types of things that it ordered. The measures ordered against Russia were slightly different because, as I mentioned, the case is a completely different situation. But this case is more similar to the Gambia-Myanmar case, and the provisional measures were very similar to that. Not exactly the same, but very similar. So, you know, and it has been following this idea that provisional measures in these cases are issued because there is an urgent situation where there are vulnerable people that need to be protected. So it has been quite consistent, essentially, in the decisions that it has been making, even at this provisional measures stage.
Talked a lot tonight about this I guess universal jurisdiction of the Genocide Convention to prevent genocide, maybe in a legal way. And this is a non-legal way to ask this question, but I'm struck by, you know, they were approaching the 30th anniversary of the Rwandan genocide and this failure to respond to the conditions that could potentially lead to genocide, and we saw what happened there. Does the ICJ ruling trigger any other states or actors to respond to any violence, or to the violence in Gaza?
I think this is an important thing to draw attention to, because, as I mentioned, every state that is a party to the Genocide Convention has an obligation to prevent and punish genocide. That's what they agree to when they ratify the Genocide Convention. And the court has found in its rulings that this obligation to prevent genocide doesn't start when genocide is already happening, because that would be absolutely absurd, because you can't prevent something that's already happening. So the obligation to prevent arises when a state is made aware of a serious risk of genocide taking place. Now, that risk had been raised before the ICJ made its order. It had been raised by humanitarian organizations, by entities within the UN. But now, with the International Court of Justice issuing a ruling that definitively says, well, there is a serious risk of genocide, like at a minimum, and it's definitely plausible here, that puts all of the states that are party to the Genocide Convention on notice that there is a serious risk of genocide and triggers their obligations. So the orders themselves are not binding on any other country other than South Africa or Israel, but the Genocide Convention is. And so coming from that, state parties, including, for example, the United States, which is a state party to the Genocide Convention, need to assess their own conduct now and their relations with Israel, because they may be liable for being seen as violating their obligations under the convention to prevent genocide. So as an example, scholars have been talking about the fact that there are countries that supply weapons to Israel, including the United States, and the need for those countries to reevaluate that supply of weapons to assess whether or not they may be contributing to this at least risk of genocide or the commission of genocide. In addition, there are many other ways that states can act. So obviously not all states are, for example, providing weapons, but there are other ways that, you know, essentially this should impact the relations. I mentioned this concept of impacting the relations with other states in thinking about how they're engaging with Israel, what is their own conduct. You know, perhaps they want to intervene in this case, because that is an option, that other countries can intervene in a case before the ICJ. And we have 32 countries that intervened in the Ukraine-Russia case. So there are different ways that they can do that. They could also consider, for example, sanctions may be one way that they can say, you know, we're going to put sanctions on Israel or Israeli entities, for example, as a way of saying, well, we're trying to act to to prevent this genocide, so to change the conduct that may be a risk of genocide.
So I think we could probably unpack even more from this case, but before we end it tonight, I want to turn it over to questions from attendees. So if you have questions, please add them to the chat. And we've got a couple of here now, Mel, so I'm going to read them for you. One coming from Charlotte. What is the conviction rate of this court in genocide charges? And what are ways that a state can be held accountable for committing genocide?
So the ICJ doesn't convict because it's a court that adjudicates disputes between states. So what it will, the International Criminal Court will convict someone of individual criminal responsibility, but the International Court of Justice will make a finding about whether or not a state has violated international law. And there haven't been a lot of cases brought under the Genocide Convention. There was the Bosnia-Serbia and Bosnia-Croatia cases, and then we skip now to the cases that I mentioned before: Gambia, Myanmar, Ukraine, Russia, and now South Africa, Israel. So the cases that Bosnia brought, the court found that Croatia had not committed genocide. It had not violated its obligations under the convention. In regards to the Bosnia-Serbia case, it had sort of technical decisions there, and as is generally perceived to be the case through the law that came out of the International Criminal Tribunal for the former Yugoslavia, there is seen that genocide was committed in Srebrenica, but not more broadly in the former Yugoslavia, and the court echoed that sentiment as well. So at the moment, there has only been one determination by the ICJ of a violation of the Genocide Convention, but we have 3 cases now. So, keep watching it over the coming years to see what happens. Charlotte, in terms of your second question about what other ways can a state be held accountable, so I mentioned sanctions. Sanctions are really important, and they can have quite an impact. In fact, I was reading today about the impact that sanctions have been having on Russia, which are quite significant. And as long as sanctions are enforced and there is, good public knowledge about the existence of those sanctions, they do have quite an impact on states and their financial situation. So they can be a strong deterrent they can be a strong changer of state actions. Other ways are essentially, there are obviously actions that states can take within the United Nations. The challenge, of course, is the United Nations Security Council in this case, because the United States, which is a strong ally of Israel, is a permanent 5 member of the Security Council, so they can veto any resolution. And I will say that Algeria, which is a current member of the UN Security Council, has indicated that it wants to start proceedings in the Security Council to pass a resolution to demand compliance with this provisional measures order of the court. And if that happens, I would probably imagine that the United States would use its veto to vote against that. But again, in doing so, it may then need to question whether it is in compliance with its obligations under the Genocide Convention.
So I think maybe to follow up to Charlotte's question and to bring it back to something you had mentioned earlier, you said there's been an uptick in cases brought before the ICJ. Do you have a sense maybe why genocide, for maybe lack of a better term, is sort of in vogue in the ICJ now?
It's a good question, and I don't really have an answer, but I have to say I'm really glad to see that states are enforcing it and taking action under it, and hopefully it's going to be a deterrent going forward. I think in the case of the Gambia v. Myanmar is a pretty hermit state. It doesn't engage much with international law. It does have one powerful ally, which is China. Its Belt and Road policy has logistical aspects that go through Myanmar, so it is quite engaged with Myanmar. but the Gambia is this little country located far away, geographically far away in Africa. And I guess, they decided that they had nothing to lose and they had these obligations, so they would uphold them. The Ukraine-Russia case, Russia is obviously seen as the bad guy, so it's quite easy to bring a case against Russia, and that has received significant support with 32 interventions in that case. So I guess, there's different reasons for bringing different cases.
So I'm going to go a question here from Jerica. I'm curious if there's a process that these international legal actors follow in order to decide whether they should put a state on trial or individuals. How do international war crimes lawyers decide to differentiate between individual war crimes from state war crimes? So I think back to maybe that differentiation between the ICC and the ICJ.
So, well, the decisions are made by completely different people. So in terms of thinking about the International Criminal Court, those decisions are made by the International Criminal Court, so by the prosecutor. However, also in terms of the International Criminal Court, there can be state referrals. So actually governments can refer a case, and the Security Council can also refer a situation to the ICC and has done so in the situation of Darfur. So that is one way that states can activate this individual criminal responsibility action, whereas the other option is going to the International Court of Justice, and that can be slightly different because they have to think about the impact that it will have on their relationship with that country, but maybe also other countries as well. So I'll give you an example. In a case that was decided in 2014, which Australia, which is where I'm from, brought a case against Japan about their whaling in the Great Southern Ocean. And that case came after a very long time of negotiations between the two countries. And it was only after a lot of negotiation between different ministers, foreign ministers, environment ministers, and so on, that Australia decided that it would make that decision to go to the International Court of Justice because they were not able to resolve that dispute. So, that's when a dispute isn't being resolved, the ICJ is there for that, between two countries. Whereas generally decisions to prosecute people come from courts themselves rather than the states.
So, a question that I had, and it relates again to Jerica's question, is you talked about the ICJ kind of following in tandem with ICC, that a lot of the cases, especially in the Balkans, had cases that the ICC had already prosecuted. So there was that evidence already gathered. Is that a matter of happenstance, or is that an actual calculated cooperation between the ICC and ICJ in terms of court cases?
There's no cooperation between the ICC and the ICJ. They're two completely separate entities that have completely different roles. So it's just coincidental. I mean, the ICC was already investigating before the ICJ case came about. So they essentially have nothing to do with each other than the fact that the jurisprudence of each court may be used in evidence by lawyers bringing cases before each of the other's courts, but they don't actually interact in terms of decisions or what their process is.
And so Megan has a question here. My question speaks to the relationship between the ICJ's ruling on plausible risk of genocide, the ICC's framework of criminal, individual, and command responsibility, and the widely shared evidence of grave atrocities, including the language of dehumanization, annihilation, and extermination that betrays genocidal intent that Israeli occupation forces and state leaders themselves are documenting, particularly on social media. Given the standard of doulos specialis, what is the legal difference between state forces, leaders attempting genocide, where Israel is failing its legal obligation to punish genocidal violence, and the state perpetrating genocide?
Okay, so just to explain a little bit from that, the term dolus specialis is the legal term that we use to refer to the special intent that is required to commit genocide. So the definition of genocide is the destruction in whole or in part of a racial, ethnic, religious, or national group. And then there is a list of crimes, individual crimes of how that can be carried out, obviously, such as killing, and causing serious bodily and mental harm, and a few other examples. But the key part of it is this intent to destroy, and that is extremely difficult to prove. And this is what makes genocide the most difficult crime to prove, because it has this extra element of special intent, or dolus specialis in the legal Latin term. And so when we get to the merit stage of this case, that's what South Africa that's going to be their biggest challenge, to put evidence forward, to prove that special intent, to be able to say that there is a violation of the Genocide Convention. In terms of, so just let me, the question, what is the legal difference between state leaders attempting genocide where Israel is failing its legal obligation to punish genocidal violence and the state perpetrating? Okay, so essentially, if I think I understand your question, is what is the difference between individual responsibility and state responsibility for genocide? So individual responsibility is where they will look at what did that individual do, what were their actions, and do they fall within the parameters of the crime of genocide? In terms of thinking about leaders and command responsibility, that is difficult, and that's one of the reasons why charges take so long to bring about, because you have to be able to make that direct connection between the commander or the superior, the civilian superior, and actions that took place on the ground, because generally the commanders and this particularly civilian superiors are not the ones on the ground doing the dirty work, so to speak. So the evidence must show that direct connection between a civilian or military leader and what was going on the ground. So that's why it's such a challenge in criminal courts to prove this concept of command responsibility. In terms of state perpetrating a genocide, what they do is they look at generally what is the state's conduct. So what is the conduct of its leaders, its civilian leaders? What is the conduct of its military? And the court will look at a pattern of conduct. So South Africa has brought in the statements that have been made by Israeli leadership, as I said, both military and civilian, and media and prominent personalities. So statements can be a really useful and sometimes extremely obvious source of evidence of whether or not genocidal intent exists. They are also obviously may amount to incitement to genocide as well, separately. So it's these kinds of things, the statements, but also looking at the pattern of conduct. So what has actually been going on the ground, which, for example, may be contrary to public statements that are made, because leadership may, they're smart. They know that they shouldn't necessarily publicly make statements of genocidal intent. But what happens on the ground, that pattern of conduct may belie what the statements say. So those are the types of things that would be looked at, as opposed to individual responsibility, where it's about what did that specific person do, and did that specific person have genocidal intent themselves?
I think your response and especially Megan's question belie the real immense legal challenges of proving genocide in a legal context. Is the South African case, is it a zero-sum game? Is it genocide or nothing, or is there a potential for other gross human rights violations, either crimes against humanity, something along those lines that maybe fall short of that genocide threshold, but still find Israel culpable for some kind of violation.
So we could do a whole other webinar about the laws of war on this situation, and admittedly, I have done that as well. But the short answer to your question is yes. So the International Criminal Court has jurisdiction over war crimes, genocide, and crimes against humanity. And I would absolutely anticipate that there will be charges brought against alleged perpetrators of war crimes and crimes against humanity. Just absolutely sure. I mean, you think about, for example, what happened on the 7th of October, you know, horrific war crimes, horrific crimes against humanity. And I would absolutely imagine, you know, that the ICC will bring charges for that kind of thing. In terms of other potential war crimes, as I said, well, we've only got a couple of minutes, but there are definitely issues with regards to Israel's compliance with the laws of war in the way that is conducting the conflict. I guess we don't have time for me to go into that, but I certainly can imagine that we will see the International Criminal Court bring charges probably on both sides of the parties to this conflict for war crimes and crimes against humanity.
Clearly this conversation could go on much longer and in a number of different ways, but I think that's a good place to end it this evening. And I want to thank everyone here for joining us tonight. If you're in the Twin Cities here and learning or having a longer conversation about the law, the Center will be hosting John Packer this Wednesday, so 2 evenings from now at 5:30 in the Ramsey County Library in Roseville. And I'll put a link to that event in the chat here. And just for some context, John Packer is a human rights lawyer with decades of experience, very similar to Melanie's, and working with decades of working with NGOs and non-governmental organizations. I guess it's NGOs. And his talk, Remember, Learning, and Applying, will highlight how we failed to live up to the aspirations of never again in the aftermath of the Holocaust. So I hope you'll join us on Wednesday at 5:30 at the Ramsey County Library in Roseville for another conversation about this. And Melanie, thank you so much. I think this is such a complicated and dense topic, and I appreciate you breaking it down and explaining the ins and the outs of Friday's decision. It was incredibly helpful.
Thank you. I hope people found it useful. I know it is complex and difficult to get your head around if you're not spending all day on it like I am.
And as a reminder, this has been recorded, and we will archive it on the center's YouTube channel. So if you have questions, you can always come back to that. But again, thank you all again for joining us. This was really great. Thank you so much.